I'd now like to introduce Professor Karl Jacoby to take us through the section on United States Indian policy, sovereignty, and treaty making.
Good evening. Good evening. Really, I'm tremendously impressed at how many people are here and all the way out in the hall. I hope folks can hear me. And I just really wanted to thank the students for putting this together. I think it's one of the best things I've seen at Columbia in ages. So I'm really just wanted to give a round of applause. My name is Karl Jacoby. I'm a professor of history here at Columbia, and I'm going to talk about the part of the syllabus about sovereignty. And I wanted to talk about this piece because sovereignty is really key to understanding what's happening at Standing Rock right now. But it's also a concept that I think is very difficult for a lot of non-natives to grasp, so I thought it would be worthwhile to have some historical perspective on it. One of the reasons it's very hard for a lot of non-natives to grasp is that we live in the age of the nation state. This is a defining feature about how we think about our communities. And part of the logic of the nation state is that everybody has a single unitary nationalism. You belong to one country and not to other countries. It's very hard for us to imagine the concept of, say, shared sovereignty over a space, or the fact that people might have multiple allegiances to multiple nations, to both the United States and to a native nation. One of the reasons as well that I think it's very hard for people to grasp the idea of sovereignty is that we're living in the age, and this is part of an outgrowth of the sort of logic of the nation state, but we live in this era of multiculturalism, which proposes that we are all hyphenated Americans. We may be African Americans, or Asian Americans, Euro Americans, whatever, but on some level there's a sort of shared Americanness here that we all partake in. Yet this really flattens out differences between groups, and particularly the very unique and very specific relationships that Native Americans have with the U.S. government, which is really unlike any other group in the United States. And again, in the American sort of imaginary, Native Americans are treated as a race. And so you can remember the infamous remark by Donald Trump, who we can all hope is going to lose very soon, that the Mashantucket Pequots didn't look like Indians, right? And that's because he's trying to impose a certain racial gaze on them. Indians are really more defined. It's not how you look. It's not an issue of race. It's really an issue of what is your specific legal and political relationship with the U.S. government. And in most of these cases, the relationship with the U.S. government is mediated through treaties. These are particular legal documents, and they are, according to the U.S. Constitution, to be considered the supreme law of the land, the supreme law of the land. And again, this contrasts with most other groups who don't have treaties that negotiate what your relationship as a white person is with the federal government in that way. The United States is unique among settler colonial societies in having so many treaties. There's over 500 treaties that the United States has signed with various native communities. If you contrast this with Australia, 0 treaties in Australia, 1 treaty in New Zealand, 11 treaties in Canada during the national period. I think this is an outgrowth of the United States' peculiar history as an anti-imperial imperial power. And by that I mean anti-imperial in that it's born in this revolution against the British and sees itself and likes to imagine itself as anti-imperial, right? Yet it is also an imperial power that then expands over North America and overseas as well. And I think this is one of the things Anne was talking about with the structure of settler colonialism. The United States does not like to think about itself as an empire. It likes to see itself as the opposite of an empire. But it really is, in many respects, with these treaties. It is an empire, right? And we need to speak clearly about what it is. Now, there's over a century of treaty signing that the United States did. Beginning in the 1770s, the first group it signs a treaty with is Lenape, the very group that the plaque that was recently placed here on campus acknowledges that we are all on Manhattan, Lenape land, right? So there's a century that these treaties are being negotiated. Each of the treaty is a product of a very specific historical moment. And so that means that the reserved rights in each treaty can vary. And I use the word here reserved rights because the way that treaties are considered legally is that Native nations basically reserve every right except those rights that they grant explicitly in treaties to the U.S. government. So the assumption is that unless they explicitly give this right to the U.S. government, all of these other rights are reserved to them as in their national status. And these reserved rights can very much vary. So one case would be the Makah in Washington. They have the right to hunt whales. They're the only group in the United States that has the right to hunt whales. Very specific, tied to their culture, they have that right. Other groups in Washington have the right to fish at usual and accustomed places. There are groups like the Ojibwe in Wisconsin and Michigan that have the right to collect wild rice on ceded land. So you can see these are very specific, often tied to the specific sort of cultural and ecological conditions of each of these groups. The point here for us is that each of these communities is sovereign, these native communities is sovereign, but they can be sovereign in different ways. Fishing can be particularly important in one case. Wild rice or something else can be very important in another way. And each of these specificities has to be negotiated and worked out with the federal government. This is unlike when you think about, say, the African American Civil Rights Movement. You can think about how the NAACP Legal Defense Fund under Thurgood Marshall could kind of map out a campaign against segregation, overturning state laws, and sort of building on one another. Treaty rights don't necessarily translate because they're very specific, right? So something that a tribe, if they're able to really exercise and reclaim this reserved right, it often doesn't necessarily translate to a set of reserved rights which may be very different for another group. This has been a sort of structural difficulty that's been in place. The other thing, another sort of structural difficulty, is that treaties also sometimes ignore certain groups. Not every Native community has a treaty that governs it. This is particularly true out here in the East, where many of these groups were very much displaced and devastated by European colonization well before the United States is created as a nation. And so there's lots of examples. I think the Lumbee tribe of North Carolina is probably one of the biggest federally unrecognized tribes. And this actually puts Indian peoples this added burden that they often have to prove their Indianness along a set of criteria that are imposed by the Bureau of Indian Affairs. Again, something that no other ethnic group has to do to sort of prove that it constitutes this specific ethnic identity as the federal government declares it. The federal government's position on sovereignty, its understanding of sovereignty, can be traced back to some treaties from the to some Supreme Court cases from the 1830s. All of these Supreme Court cases are brought by the Cherokee Nation. They're brought in opposition to the Indian Removal Act of 1830. The Indian Removal Act is one of the clearest statements of the settler colonialism that Ann Spice was explaining to you so well. This is a policy that all Indian peoples, Cherokee, Chickasaw Creek in the southeast, needed to be relocated all the way west of the Mississippi. This is basically ethnic cleansing, right? Though again, this is one of the things we don't normally talk about. We don't talk about empire, we don't talk about ethnic cleansing. But this is basically ethnic cleansing. The Cherokee contest this. They bring their case all the way to the Supreme Court. The Supreme Court rules that the Cherokee are not a foreign nation. It rules that they are not a state, but they are rather a domestic dependent nation. Domestic dependent nation. That's the term that still continues today, all the way down from the 1830s, from the era of Indian removal. Domestic dependent nation. Now, what does that mean? I mean, it's a kind of hard term to get your head around, right? What part of that phrase do you emphasize? A lot of tribal communities, of course, like to emphasize the last part, nation. The United States, the government often likes to emphasize dependent, right? That we get to make the decisions for you. Because of this vagueness about what does it mean to be a domestic dependent nation, sovereignty is really not a fixed, clear condition. It's something that has to be continually renegotiated and really refought over continually by Native communities. And this places another sort of set of added burdens on Native communities. The first of these would be that the venue for deciding a lot of these cases often is in a court and governmental system that is settler dominated, not particularly sensitive to, if not downright sometimes hostile to Indian rights. If you quote the original Supreme Court decision that came up with this term domestic dependent nation, the justices conclude that, quote, the rule of nations regards Indian tribes as nothing more than wandering hordes held together only by ties of blood and habit, and having neither rules nor government beyond what is required in a savage state. And that sounds outrageous, but that's still really the mindset that's governing how relationships should work with Indian peoples. Even if you win in the court system, there's a question of whether you're going to get the government to support what you do. In fact, the Cherokee actually win one of their Supreme Court cases against Indian removal in the 1830s, but President Andrew Jackson refuses to acknowledge the judgment of the Supreme Court and removes the Cherokees. Anyways, as everyone knows, it's the famous Trail of Tears, or the infamous Trail of Tears. The other issue here is that on face of it, it would seem like this is equal government-to-government relationships. The federal government and the domestic dependent nations can sort out what the issue of sovereignty is supposed to be. But you have a very large, powerful nation, the United States, often dealing with much smaller nations, much less wealthy, and it places an incredible burden on these nations. When I've been involved in litigation over tribal issues, treaty issues, to have to pull together the legal resources, to pull together everything that you need to negotiate with the federal government is a tremendous burden, disproportionate burden that's being placed on Native communities. So it seems perhaps equal, but it's quite structurally unequal. Now, this question of sovereignty is at the heart of what's happening out in the Dakotas around DAPL. Article 2 of the 1868 Treaty of Fort Laramie guarantees that the Standing Rock Sioux tribe shall enjoy, quote, the undisturbed use and occupation of their reservation land. Now, as you've seen from the movie, they already have a history of knowing that that clause has not been respected, that a lot of the best land on the reservation was flooded by dams, much of that water going actually to non-native users. Although the pipeline itself isn't on the reservation, it's close to the reservation. If it were to leak, and these pipelines leak all the time, if the oil will come onto the reservation, it will go into the water system that the reservation depends on. There, it would seem, at least to me, I'm a historian, I'm not a lawyer, certainly calls into question the idea that the Lakota are able to enjoy their undisturbed use of this land, right? So there's two final points I just wanted to bring up for those of us who are non-native to consider. The first of us, that for those like myself who are non-native, that we need to acknowledge, as again I think Anne said so nicely, these structures of settler colonialism that we are the beneficiaries of. That we are really the beneficiaries of this tremendous gift that's very rare in the course of human history, a whole continent that was opened up by virtue of these treaties. The challenges of undoing settler colonialism are immense, given that there are now large numbers of non-native people living on native land. But I think the most basic moral baseline, the very minimal moral baseline that we should be doing, is that we ought to insist that the government honor the treaties that is signed in our name, right? And the other tenet of treaty law is that the treaties are supposed to be interpreted as the tribes themselves understand them, right? So that's another sort of basic moral baseline that should be employed in this situation. And the second point here is that Native nations, when they've been trying to exercise their treaty rights, this is often to the benefit of all of us. The cases that I know best in Washington, tribes there have been very active in litigating about the salmon runs, about making sure that their habitat is protected so that the salmon that they have a treaty right to shall continue to be abundant so that they can actually harvest this resource. But in doing this and protecting the environment, they're also protecting the environment for everyone else, allowing everyone to have salmon. In this case here in Standing Rock, the watershed is important, of course, for the people on Standing Rock, but it's important for everyone else who touches this. The ranchers, the Missouri watershed, there's a lot of people who are also dependent on this watershed. So this is a struggle about Native sovereignty, but all of us stand to benefit by supporting Standing Rock. Thank you very much.